Welcome to Engaging Experts, the podcast that goes behind the scenes with influential attorneys. Our guests will describe their practice and expertise. Then we will go deep on various topics related to effectively using expert witnesses.
Hi, this is Russ Rosenzweig. I am the CEO and one of the co-founders of Roundtable Group, and also the host of this podcast series, Engaging Experts. We have a great guest for you today. Bernard Tisdale is the managing principal at the Charlotte office of Jackson Lewis, our resident expert on the topic of privilege and confidentiality in the expert witness context, and a fellow aficionado on the nuances of Southern barbecue cuisine.
Yes.
And before we dive in, Bernard, let's have a quick message from our sponsor.
This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Bernard, welcome.
It's good to be here, Russ. Thanks.
I'm so glad you could be here. And I'd love to start with just a bit about your unique background. So you went to Clemson to study chemical engineering. Go
Tigers.
Worked subsequently as a nuclear engineer and then went to law school. So, how did that happen? And how has your engineering training influenced your practice of the law?
It was more falling into things as opposed to any great plan. In high school, I was good at math and chemistry. Well, okay. Chemical engineering. I heard it was the hardest degree at Clemson. Okay, I'll do that. Then I graduated in the recession in the early 80s, and you couldn't buy a job. So I knew the recruiter at the shipyard in Charleston and joined the nuclear engineering department for 3 years, knowing that I most likely would be going back to school at some point. An ex-girlfriend suggested law school, and the rest, as they say, is history. With engineering, you're able to get a definitive answer a lot of the time down to the nth degree. In law, there is no answer. It's all gray. So I don't know that my engineering degree prepared me too much in that regard, but it did teach me how to put my butt in a chair and work for hours on end, which came in handy in the field of law.
Mm-hmm. And let's talk about how you're spending some of those hours on end these days, because many of our listeners are fellow business owners and executives like me who, like me, are constantly needing to engage counsel. So tell us a bit about your practice these days, what you're focused on, and a bit about the Charlotte office.
I just started the Jackson Lewis Charlotte office. I'd been with a major competitor for a bunch of years. I've been practicing employment law since 1995. I practiced with an insurance defense firm doing anything from car wrecks to multi-district litigation over products liability. A lot of my practice focuses on employee safety and health. I do a good bit of OSHA compliance, along with the associated ADA, FMLA, workers' comp, just everything that goes into workplace safety and health.
Well, that's an increasingly important topic these days and will be even more so, in my opinion, post-pandemic. And, Bernard, this is an expert witness-focused podcast, so I'm a little curious about how often you need to engage expert witnesses in the course of your practice, and what do you do when you need experts?
For starters, it's going to depend on the type of litigation that I'm performing. In employment law, it's not often that I will have to retain an expert. If I do, it will be a human resources practitioner or an expert in economic damages. I had a case many years ago that options were a key point of damages, and I had to find someone that could find the present value of a future set of options. When I need an expert, it tends to be in a unique situation, especially with some of the employee safety and health work that I do. I have retained experts in metallurgy, in medicine, very specific fields of medicine, and expertise in medicine, expertise in industrial hygiene. Specifically, I've done a lot of work in the area of Legionella with a few clients where I have needed some experts in that regard, and you can have various subsets of expertise in any of these areas. So the key is finding the right expert with the right knowledge for what I need. Typically, I have been looking for someone, a unique expert with a unique subset of knowledge, because you're always looking to play the game of my experts better than yours. And to have one with excellent credentials in the field that you're concerned with really will just play well in getting a resolution to the case, and most likely play better in front of a jury. So that's kind of the realm that I am hiring expert witnesses.
Yeah, and I think we've had the privilege of working together over the years on a few occasions in an expert witness recommendation context. Could
You
you say
have.
a little about, when is it better to use someone like Roundtable Group versus finding experts on your own?
Yeah. Typically, I've found I can find generic experts through contacts within the firm. That HR expert or an economic damages expert or someone that is expert in pay practices. But when it comes to employee safety and health, I'm having to step outside the confines of my firm and, or say in the construction field, and find someone with a very unique skill set. And I can't do that as an attorney, outside counsel, without the assistance of a expert witness search service. And yes, I've gone to you guys several times and with trying to find that unique set of expertise.
How did we do?
You did good. You did good. I mean, you're never nobody's going to have access to everybody, but the couple of experts that I have, just the process that you have utilized allowed me to find that unique expert. And that's kind of, to me, is key.
Well, it's always a privilege to work with you and Jackson Lewis. And speaking of privilege, not sure if you know this or not, but you actually have been a great educator of us on this topic of privilege and confidentiality in the expert witness context. And many of our listeners are peer attorneys of yours, and also our beloved expert witnesses themselves listening. So I thought we can chat for a few minutes about some of the nuances of privilege in the expert witness context. And maybe you can start with, what is it? Why is it important? And what should experts be aware of, like when they're contacted by an attorney or by a firm like Roundtable Group about a matter?
One caveat, one disclaimer to the entire discussion. The rules on privilege, attorney-client privilege, Work product protection can be very unique jurisdiction to jurisdiction. In general, what we're going to talk about is, the practices are fairly uniform, but it's always the nuance that's going to get you. So with that, take what I say and then go research it. When retaining an expert, you've got two concepts: the attorney-client privilege, which is communication based with an attorney, to and from an attorney, for the purpose of the attorney providing advice. Now, that is important in some context where an entity has tried to use, say, a lawyer to protect the work of an outside consultant, where there is no, it's not being done in anticipation of litigation for work product and not being done for the attorney to give advice to the client. In that situation, courts, that relationship can be attacked, and the courts can kind of pierce that privilege veil to get at whatever was being talked about in those communications. So they kind of a word of warning to attorneys and experts: make sure that it is forced in some way to give advice to the client. Work product, work that is being done in anticipation of litigation, that can be in varying degrees. Russ, you asked me for an example when we were getting ready for this discussion. Came up with, one of the areas that an employer may need to hire an expert is evaluation of their pay system. Are we equitably paying our people in the various categories of jobs? And not being discriminatory, not having a disparate impact on any particular demographic group. I think that is an area that has been increasing over the last 10 years, and it's going to continue to increase. You're possibly not in anticipation of litigation. It could depend. You might have somebody that has made a complaint, so you might have a colorable argument that it's done in anticipation of litigation. But your best protection is probably going to be that attorney-client communication for the purpose of providing advice to the client. So all the communication is going to have to be through the attorney and not to the client.
So just to clarify there, if one of my beloved business owner executive peers decides to have a thorough and rigorous study of the pay practices at their company to ensure equity,
right,
and fairness, which is a good thing these days. It should be done. If they were to do it like outside the scope of legal counsel and just, call, say, me to hire an expert consultant to conduct that analysis, and then find that it's deeply flawed, and there are problems with the pay practices, that is totally discoverable in any future litigation. Do I have it right? But if they are working with you and your team and you hire the expert in the context of litigation preventativeness or, concerns about possible litigation, then it's privileged and confidential. Do I have it right?
Yes. I'm not going to say you'd be correct 100% of the time, but in that scenario where you don't have a claim, you're not going to, or in anticipation of litigation, you're not going to have work product protection. And without an attorney, you're not going to have attorney-client communication.
Yeah, it's interesting to me because, doing it without their attorney may have started as just a goodwill, kind of inquiry gesture. Hey, we want to make sure everything's fair, but it could backfire, sounds like, and turn into serious litigation. But if it's done with the guidance and under the tutelage of the legal team with experts being engaged in that context, then it's both accomplishes the purpose and is preventative, perfectly confidential, and can never be really used against them in a court of law. Did I hear it right?
That's the end goal. Trying not to have it used as a sword against you by virtue of going through an attorney, having the attorney engage the expert in providing advice to the client. It also allows your business to correct the issue at a reasonable pace. Say, for example, somebody finds out about the study and it's not privileged. If you haven't done anything about it, or they found out how long the problem has been in existence, damages start going up quickly.
Right.
And lots of people find out about it and it's just bad. So you get to fix it on your own terms.
Right on. I've seen over the years, 27 years, God help me, been in the expert witness business. Often experts are engaged kind of early on in a consultative context rather than in a testifying role. Sometimes, in the employment context, just as an example, there might be concerns of theft of intellectual property. And so, any number of my peers who are running high-tech companies an employee leaves and perhaps they have concern about theft of intellectual property and are contemplating retaining counsel, on the plaintiff side, and are assessing the likelihood of theft, etc., and engaging experts in that context. There's not a litigation yet. Nothing's been filed. It's just, kind of a due diligence, thorough and rigorous fact-finding process. Is that privileged?
In the scenario that you've got, if you have absolutely no inkling that this individual stole anything from you, maybe not, you might not have that in anticipation of litigation protection. However, going through an attorney can at least give you some protection, and the advice would be, do you have a claim against this individual who left? What are the laws of the theft of intellectual property in whatever jurisdiction that you're in? So yes, you can protect, again, depending on the jurisdiction, you should be able to protect that kind of investigation.
Sounds like the common thread here, Bernard, is, I guess I would use the phrase, materials prepared in anticipation of litigation. Would you say that's right? That's kind of the key metric?
That's one aspect of it, Russ. But a lot of the times, like we mentioned with this pay disparity issue, you might not have that anticipation of litigation. That's where it becomes all the more imperative to hire counsel to engage the expert and pass the expert's work through the attorney to the client for the purpose of advising the client on what to do. The providing advice aspect, I think in reality can be a hoop to jump through that's fairly easy for if you're hiring the right counsel in the right area of law, or maybe outside counsel that's been working with you for an extended period of time, got that relationship of providing advice, you should be able to protect it.
Very good. Let's talk about some best practices that attorneys and experts themselves should be aware of, just to kind of optimize and ensure their work product is covered under attorney-client privilege doctrine.
And your take in the context of best practices, we're going to be taking it in context of trying to take into account the work product doctrine along with attorney-client privilege. And you're also, for starters, keep in mind that are you going to want this expert at some point to either testify for you or not?
Right.
There is a procedure and practices that you can take advantage of for someone to be a non-testifying expert. And you're going to follow a lot of the same processes with respect to engagement. And it's more on the attorney side on how to handle it there within a piece of litigation. So the best practices we're going to talk about would apply testifying, non-testifying. But I think it's good for the attorney and the expert to know what's the end result. What are we working toward with your work, Ms. Expert? For starters, you're going to need an engagement letter between the attorney and the expert. That is going to set forth the terms of the engagement. But the bigger role of that is to start creating that attorney-client communication funnel, for lack of a better term. And the engagement letter needs to set out what the attorney's expectations are. Set out, is the expert going to be utilizing other individuals? They may be with an expert witness company, lots of engineers that provide investigative services and testimony services. Who is going to be engaged? My preference would be that those individuals be identified in the engagement letter, and possibly those individuals sign off on the confidentiality structure that the attorney engaging the expert wants to pursue. In that regard, okay, attorneys, find out about your expert. If you can, get recommendations, understand what's their history. Are they experienced in this area? Are they not? You're going to have to, many times your expert's not going to have experience in the litigation process, and you're going to have to say, okay, for starters, create a folder on your computer, on your desk that's called Smith litigation. Everything goes in that folder. It's not shared with anyone else. You put it under lock and key. You're maintaining that confidentiality. Everything that you can do to maintain the confidentiality is a good thing. How do you want documents marked? Documents that you create, the expert creates. How is communication going to be marked? Attorney-client privilege, work product, protected, confidential, personal. Really, these days in the era of emails, keywords that can be found in documents and emails to make it easy for someone searching to find those words and then mark them as privileged. In a million document email production, the easier you make it to find privileged emails, the better off you're going to be. I am retentive when it comes to document control. I typically I've got my own numbering system that tells me when and where I have received a document. Then identifying the documents with that numbering system that go to the expert. So if I can tell when, say, the expert is giving testimony later and pulls up a document, I see the number, I know it came from me, and I know how it got it, and I know how he got it or she got it.
Right.
Billing, I think, is also important. Bills, in my own humble opinion, ought to go to.
Part.
Pardon?
That's my favorite part.
Billing, once again, you're trying to maintain that attorney-client communication. Billing to the attorney, but with the understanding that it can be addressed to the client for purposes of payment.
Right.
That way, you're giving it a little bit of a filter through the attorney in order to protect the communication. Because a lot of bills are going to have time entries and descriptions of activities.
Right.
And all of those activities are done for purposes of the attorney providing advice.
Right.
Another big issue is going to be what kind of documents the expert needs to create. Now, granted, experts, anybody evaluating or reviewing a bunch of documents or reviewing a piece of machinery, examining a piece of machinery, a widget maker, are you going to have to prepare a report? The expert and the attorney need to talk about when exactly that report, if one is needed, when it gets prepared. Sometimes you find out from the expert just what's your opinion, you get the case settled. You don't need a report, don't need to pay for it. It also minimizes, what might get discovered should the attorney-client privilege, work product doctrine privilege get pierced by a court at some point. If you've already prepared a report, then it gets discovered. Talk about in terms of if the expert is going to have access to, say, original data or the widget maker that failed. You don't want your expert acting without the attorney's knowledge, because in a lot of situations you may need to understand what the expert's doing, and that the expert does not take action that you don't know about, maybe don't need to talk to others about. So, basically keep open communication every step of the way.
Now, let's say, Bernard, that we are following this to the letter. And, we have an expert witness that listened to your podcast, and they're under the tutelage of a skilled lawyer, and they're following all these practices. And they have their proper folder, attorney-client privileged work product folder, and the case is moving along. And at some point, the opposing counsel says that, hey, we want to see your expert's work product. Mm-hmm. How much of what's in that folder can opposing counsel see?
Right. For starters, if the individual is not going to be testifying, and there are other ways to get the information in the file, if they're not testifying and they can get the information other ways, they're not going to see it. Now, if they're going to be testifying, they're going to get a look at everything. Yeah. So it's kind of like you need to play nice when you're sending emails. Don't call anybody a jerk, and be polite, and no side commentaries in what you see or what you've heard, because somebody else is going to look at it. In some situations, an expert might be able to develop knowledge that, after the knowledge is developed, cannot be recreated. Mm-hmm. Data, mm-hmm. A look at a widget maker that gets destroyed by a hurricane.
Right.
In those situations, then upon a motion by the other side, they're going to be able to look at the expert's information because it can't be obtained anyway else.
Well, I guess I have a clarifying question, just as your plain old non-lawyer, regular old CEO here. What's the purpose of going through all this hullabaloo around attorney-client, protecting and having attorney-client privileged work product if, for your testifying experts, the opposing counsel can just see everything anyway?
You have the ability to make the decision that you don't want the person to testify. Mm-hmm. It could be, and I try to hire the best experts mm-hmm. who are going to tell me that either, yes, my theory, what was the line off of My Cousin Vinny? I mean, does the prosecutor's theory hold water? I need my expert telling me if my theory holds water, or if it doesn't hold water. And if it doesn't hold water, guess what? I'm going to pay that expert.
Yeah.
Classify them as non-testifying.
Right on.
And the other side ain't getting it unless they have developed some type of information that can't be duplicated.
So worst case, God forbid, our expert does a lot of work and research and analysis and presents a report, and it's not to your liking. It actually, perhaps it helps you hone and refine and perfect your, legal strategy, but it's definitely not something, that you want to present as that expert being your testifying expert. So in that case, it was good that we were to the letter of the privilege and confidentiality best practices, because now you're not going to designate that expert as a testifying expert. You got the benefit of his or her knowledge, and everything's protected. That do you have the gist of it?
I've taught you well, Padawan.
Thank you, teacher.
I've taught you well. And you bring up another good point, especially when it comes to drafting reports. It becomes a very fine dance between the lawyer and the expert, on the lawyer imposing himself on the expert's drafting. You don't want.
How important is it for you to babysit and police the drafting of the expert's report versus just letting them do their thing?
Well, I think you are also at the same time trying to see, all right, what's your opinion going to be in your report? If I don't like your opinion, I'm not going to get you to write a report.
Right.
Now, if I like your opinion, walking through the drafting can also assist the lawyer in determining, are there holes in the argument? I mean, does the expert have the correct facts? Does the expert understand the situation? Or is he pointing out things I don't understand and I need to figure out? So it's to the extent that you can break the process down with your expert to layers and individual baby steps, the better off you're going to be with an end result that supports your position, or stopping at a point where you figure out it's not going to support your position and you need to stop work. It's a delicate, it can be a delicate dance.
Right. I want to cover one more nuance topic. We've been pretty thorough here about confidentiality and privilege. In what I would call the post-retention space of the expert witness. Roundtable Group is in this unusual space of, lots of pre-retention work. I mean, for 27 years it took us, but finally by now, every day we have dozens of requests from your peers for help with expert witness recommendations. And one thing we really pride ourselves on here at Roundtable Group is being really thorough and rigorous about that expert recommendation process. And we have, thorough discussions with counsel about what the ideal expert looks like. Often we're reviewing complaints and patents if it's an IP case. Sometimes we're asked to do a little bit of due diligence and kind of run the basic case facts by experts and kind of assess if they feel they're qualified and interested. And we also pride ourselves on, typically we are on the interviews with expert and client. Roundtable Group is on those calls because we learn a lot, can often help hone and refine and perfect any future further search work that needs to be done. So, out of curiosity, is that pre-retention work considered privileged?
I haven't researched this one. I think it could be possible, I would want to engage Roundtable Group, any expert search firm, for the purpose of locating an expert, and the Roundtable Group, any other expert witness group, communicating with me directly.
Mm-hmm.
And okay, that's going to start creating, I've engaged you, I'm going to be paying you a fee to advise me on folks that are out there. Conceptually, I can see a good argument to protect that relationship. I would want to be very careful, though. I think you're starting to dance a little on the edge, and especially depending on the jurisdiction.
Right.
And most lawyers are going to know you only feed the expert really common facts and facts that are easily identified and are not going to be in dispute as you start going down the road of expert retention.
Yes.
And once you kind of find somebody that has that narrow set of experience, all right, then you start getting down into the nitty gritty in order to determine what that opinion is. At some point, the lawyer needs to make a decision. Do I want to go ahead and write an engagement letter with this expert to really kind of solidify? And you may not use them,
right,
but you've at least protected yourself, protected your client, and the communications you have with that individual. So, like I say, I haven't researched the issue. I think it could be possible, but I think the attorney needs to take steps in protecting the client by formally engaging whatever group is going to be making that search.
Very good, Bernard. Thanks for going out on a limb here with some cutting.
Yeah, no, don't tie me down.
Right on. Good disclaimer. I guess let me just ask, any other nuances or details on the topic of privilege and work product in the expert witness context that you care to share?
I think, we've given the basic rules of the engagement and the construct for engaging experts. Before any attorney engages an expert, figure out what the law is in your jurisdiction on what you can and can't do with the expert. What information can you feed it? Under what circumstances are you going to be able to protect that information? After you figure that out, being meticulous in how you engage someone to provide you with expert advice so you can advise your client. But because it's all on a sliding scale, it's not engineering anymore, it's all law. The more arguments that you can make that I protected this via the attorney-client privilege, the better off you're going to be able to protect the work of that expert, unless and until you want to open the floodgates and allow everybody to see his or her work.
Excellent, Bernard. Thank you so much. I guess my final question is there anything you care to share with our listeners regarding the nuances of Southern barbecue cuisine and your favorite Charlotte?
I was working with a fella at the Charleston Naval Shipyard many years ago, and he came to me and he said, "Bernard, I am an expert on barbecue." And I said, "Oh, really?" And there was a place in Virginia Beach, Virginia, that had the best barbecue known to mankind. I said, "Wow, well, I'm just going to have to go there." Is it mustard based, ketchup based, or vinegar based? And he went, "Huh?" He was no expert. Now, being from the South, it's pork. Mm-hmm. It's not brisket. And okay, that's okay. Certain parts of the South, it's going to be fighting words to call anything other than chopped pork barbecue. Up in Lexington, it's going to you're going to have vinegar-based sauce. Down in South Carolina, you're going to have mustard-based with ketchup-based, kind of thrown a little bit everywhere. So my favorite spot is, dang, and I cannot remember the place's name, a little restaurant on Wade Hampton Boulevard right outside of downtown Greenville. That a little, it's best the hole in the walls. Good stuff.
All right. Well, that's a good enticement for any of our listeners who would like to connect with you.
We'll talk barbecue
about any of these expert witness related privilege concepts. As an extra bonus, they can get the name of that, your favorite restaurant. So how do our listeners reach you if they want to reach out to you to discuss further?
I am easily Googleable. Jackson Lewis is a national labor and employment law firm across the country. My email address is bernard.tisdale@jacksonlewis.com, or you can find me on our website, jacksonlewis.com.
Great. And that's Tisdale, Tisdale. Bernard, thank you. Thank you for being our honored guest. Bernard Tisdale, ladies and gentlemen. Thanks again. Cheers.
Thanks for listening to Engaging Experts. Be sure to click subscribe so you don't miss our future episodes.